Today, we're diving into a case that redefines probable cause in the age of legalized hemp. Imagine this. You're stopped by police for a routine check and a drug-sniffing dog signals something. But here's the twist. The alert could be from legal hemp, not illegal marijuana. So the question is, can law enforcement really use that alert as probable cause to search your vehicle? That's exactly what's at the center of State of Tennessee versus JuJuan Lee Green. In this case, the defense argued that a canine alert shouldn't automatically justify a search, not when the scent could be legal hemp. But the Tennessee Supreme Court didn't see it that way. They ruled that, in the totality of circumstances, the dog's alert still provided probable cause. So what does this mean? Could this decision affect your rights on the road? Join us here at BlackJusticeMedia as we take you inside the courtroom drama. Let's dive in.
Interesting case, this one involving dogs, always a favored topic in this group. So we're happy to hear your arguments. Mr. Hemner, would you like to call the case?
State of Tennessee versus JuJuan Lee Green.
Madam Chief Justice, members of the court, may it please the court, Gregory D. Smith, Montgomery County Bar, and for the two justices that first sat on the Supreme Court from Memphis University's law school, welcome home. This is a case that stems from a 2000 decision, State v. England. This court said a mere sniff by a dog can amount to probable cause. In 2018, the U.S. Supreme Court started to have to look at a different statute from Congress that's flipping everything on its head. That statute was the 2018 Farm Bill that made hemp at 0.03% THC legal. In 2019, Governor Haslam's cabinet went through the legislature and adopted that same rule in Tennessee. It was put in place in April, and that's where we come to today. What we're offering today, Your Honors, and what we're asking this court to do is have a declaration of independence from England. The England case, as presiding Judge McMullen has said in one of the several cases below, it's fractured the logic behind England because at the time England was put into place, any smell that was an illegal substance qualified as probable cause.
Mr. Smith, what part of England are you wanting to overrule?
I'm wanting the
Probable
whole thing
cause?
overruled.
Okay. Are you saying we just throw out dog sniffs now and that can't be part of the totality of the circumstances for probable cause?
No, sir, not at all. I'm saying throw out the part that says it's automatic per se. And the reason for that is this court can jump back 100 years to the 1925 case of Copley v. State, where Chief Justice Grafton Green said, using the bloodhounds, it's the same logic as I believe Justice Campbell said about 2 years ago in a decision. Sometimes the processes of today's technology being forced into a structure that pre-existed and didn't anticipate it causes problems. That is the situation we have here. I think that it can be part of a probable cause. That's not a problem. The problem is, in this particular case, the only basis for the stop was one, early February, driving down the road in the dark in Clarksville, person had their high beams on. That's why the stop.
Mr. Smith, I want to go back a moment, if we can, to some of your comments about the England case.
Yes, sir.
Can you show me where in the England opinion it holds that it's the dog sniff is per se probable cause?
It does not say per se, but what it says is it can amount to probable cause, and the application has been that the dog sniff in and of itself.
But I thought you said you wanted us to reverse England because it stood for per se
It actually says,
It
it's talking
rejects
about
that.
some Court of Criminal Appeals cases, it says, to the extent, however, that these holdings represent a per se rule, we reject it. So
Yes, ma'am.
what do
It
you
does-
want us to, do you want us to clarify cases that have later misapplied England? What do you want?
Yes, ma'am. Actually, there are 3 cases that came up through the system all around the same time, all 3 out of Clarksville. And the trial courts all found, because the sniff in and of itself, and I think the phrase that one of the judges used was, the sniff is not up to snuff. Basically, what was happening is the basis of the stop, the basis for the investigation was a dog alerting. The problem was, if the only thing they were stopped for was bright lights on a dark night, that shouldn't in and of itself have allowed anything to go further. The passenger had a backpack sitting at their feet. Over my right shoulder, there's approximately 100 students. Most of them have a backpack at their feet. That in and of itself does not amount to probable cause. Yes,
Well, it wasn't only the bright lights or only having the backpack. I mean, there was some evasiveness in answering questions about the backpack.
after they were taken out of the car, yes, ma'am. But the car had been stopped, there had already been a seizure, and then they took him out, and then there was questions starting to be asked.
Well, there were other factors there. He had the strong odor that he said, well, that's just my pine
They-
hanging here.
They
And there-
said, the officer said, and this was done by stipulation, that there was a strong odor. Did not say what that strong odor was. In response, the people in the car said, we have 3 pine tree things, and it was never disputed. So, yes, they said there was a strong odor, but it did not say what kind of strong odor, what to do with that strong odor, or if that prompted anything further from the officer. The record just doesn't say. So we are down to the dog. And with that, the dogs were trained to alert to 4 substances: cocaine, meth, marijuana, and heroin. But the dogs are not trained to indicate which substance, which is frankly a little bit ironic, because I think there's been studies showing that a dog can be trained to do a different reaction to a different stimulus. So you literally could have a dog, if they smelled cocaine.
Is that evidence in the record?
No, but it's public information that,
Well, we have to have something that's in the record if we're going to rely on that to say that they could have done something else. If it's not in the record, we can't rely on it.
yes, sir, I understand that. I do think that we can.
Well, then let's stay off of issues that are not in the record.
Yes, sir.
Well, let me go back to England for a minute, because I'm trying to home in on what you want us to do differently. I mean, the holding in England on the very last paragraph before the conclusion says, coupled with the deputy's testimony with regard to the defendant's demeanor, the canine's positive alert provided probable cause. That
And-
sounds like a more or less totality of the circumstances, or approaching that. It
And-
doesn't say it, but,
And actually, later cases do talk about a totality of circumstances. And in that particular case, I think that if you looked at the whole picture, that would work. And I think that a totality of the circumstances that includes an officer smelling, and the state on a lot of their cases talk about there was a smell of marijuana. There was something that happened. There was a knife that was shown. Something, taking it beyond just simply a regular stop. We believe that the England case needs to be completely clarified, that you have to have something to go with it for probable cause, not just relying solely on the sniff itself.
well, how does that help you here? Because there are some factors. They're not the strongest I've ever seen, but there are some there.
Well, but they all occur after they're taken out of the car. They're already seized. So we take the position that the officer could have said, hey, turn your lights down, and that should have been enough to let him go. And there are multiple cases that talk about, unless there's something to trigger further suspicion, just a basic traffic stop for a minor infraction. And this court has said at least twice in '03 and 2000 that there are no perfect drivers. Everybody does something that's not perfect. So that if you look at hyper-technical, frankly, nitpicks for a stop that automatically turn into a seizure, then you're sitting in a situation that you're giving free hand to basically searches at any point.
Well, but we can all agree, can we not, that courts all around have allowed pretextual stops for many years.
But a
So
stop,
are you advocating that we stop all pretextual stops at this point?
no, sir. I am advocating that if you're going to do a search of a vehicle for drugs using a dog, that you have more than just simply the pretextual stop.
But the dog sniff is still, a positive alert from a drug dog is still probative of whether there could be drugs in the car. Would you agree with that?
Yes, but on the bloodhound arguments that the Copley case did, and at that time, Judge Daughtry, later justice and now on the Sixth Circuit, she said in the Barger case, you can't cross-examine the dog. And so what's happened
I'm
is
sorry, what
now
did you say? I missed that. Can't what?
can't cross-examine the dog.
Cross-examine, okay.
So you've got to have the officer saying what they saw, explaining what the dog was doing, why it was doing it. And at this point, you can still use 3 of those substances and do the exact same basic process, and there's not a problem. But the problem is, since the dog can't tell you which one that it's alerting on, you either need to do one of 2 things. Either teach the dog separate alerts so that if it says, I smell heroin, it does A, I smell cocaine, B, or simply eliminate the substance that now smells identical to a legal substance, take the marijuana out, and then you're back to the same scenario that it works. But as long as you're looking at, depending on how you math it, 3 out of 4 chances are right, or 4 out of 5 chances are right. But because now there's always that one chance that it is simply legal CBD.
So you're saying in those instances that even if you can still have the officer come up and testify that he recognizes the smell of marijuana, correct?
Yes, sir. Yes, sir.
Well, let's take the logical extension of what you're arguing with regard to the dog. If the dog can't distinguish between cannabis and marijuana, how can the officer distinguish
May
between?
not be able to, but they can take the other objective factors and apply it with it.
Well, but the officer can do the same thing when it's a
has it not?
positive alert from a drug dog, right? I mean, you seem to be, if it is would you agree that it is a totality of the circumstances test?
Yes, ma'am.
And if it is a totality of the circumstances test, then you can still consider the positive alert of the drug dog as one of the factors in that totality of the circumstances test. You can still consider the evidence going to the training and reliability of the drug dog, just like we've considered up until this point. So what changes? Are you saying that you have to have more more additional circumstances, additional facts that would establish probable cause beyond just the drug sniff or the dog sniff?
The easy fix for this scenario right now would to be either take marijuana out of the list of the ones that are trained to sniff.
Well, let's talk about what's real for us,
Yes,
okay? Because we can't issue an opinion saying, please, in your training of dogs, please separate out marijuana. So in the realm of things that we can actually do in an opinion, I'm not sure what you are asking us to do.
That's where we get back to declaring independence from England, is that if this court says if the dog is trained for marijuana and cannot show a differentiation of what it's smelling, that's not probable cause.
But again, that's not England. England specifically rejects the per se test, and in essence, and as Chief Justice Kirby said, they don't use these words, but they, in essence, adopt the totality of the circumstances test. And you've now said, agreed with Justice Campbell's question, you agree that's the totality of circumstances, so why do we need this independence from England?
Because as long as one of the substances that they can alert on is a legal substance, you're looking at people being subjected to search and seizure possibilities that have legal substances on them.
This is about, oh, go ahead.
Let's talk about the totality in one of the briefs, like when a hemp dealer leaves the job and he's stopped and there's an alert, and more likely it's legal hemp in the car, correct?
Yes, sir.
Now, isn't all that part of a totality of the circumstances scenario?
But if that same hemp dealer leaves 3 days in a row and gets stopped 3 times for the same reason, basically it becomes a scenario to where the hemp dealer has to choose, do I want to be stopped by police all the time or do my job?
Well, never mind, I won't make that comment. Go ahead.
Well, probable cause, it's probable cause, right? It's not, you don't have to be certain. That's the whole point of the probable cause test, is that it's a lesser standard that justifies the search.
Yes, ma'am.
And even when there's a possibility that the dog could be alerting to lawful hemp instead of unlawful marijuana, there still is a certain probability that it could be unlawful. So what, I guess I'm going back to the same question that's been asked by some of my colleagues, but I mean, what exactly are you asking us to change in our approach to looking at probable cause in this context and examining the totality of the circumstances?
Well, an analogous scenario would be gun permits or open carry. If it's legal to have a gun, but you're stopped and searched because you have a gun, it's going to put a chilling effect on exercising your rights. As I say, the easy answer to the questions that have been asked is if you take the marijuana out of this scenario by saying, unless you can show that it was not this, that takes care of the problem.
I'm still confused, and I've listened to the questions that you've been asked and listened very carefully to your answers. What are you asking us to hold? Are you asking us to invalidate dog sniff?
No, sir.
Okay, so you would agree that a dog sniff for marijuana can be part of the totality of circumstances, right?
To the extent that if that is the basis for it, if the dog sniff is the basis for the search, that's what needs to be stricken.
If it's the only basis.
Yes, sir.
Okay.
If it's marijuana.
So but they wouldn't bring the dog in without some basis for bringing the dog there in the first place, right?
Well, using as an example, I believe about a month ago, the Chief Justice had a decision on.
And Mr. Smith, can you just please answer my question? Would the dog be brought in without some other indicia of probable cause?
Yes, sir, at times it would. And what happens is, if it can be used as a conduit for either harassment or for the Machiavellian, the ends justify the means, Manukin, I'm sure I just butchered that name, a decision from this honorable court from about a month ago, even talked about court officers at times will step far beyond what their right and their obligation are. The fact is, the U.S. Constitution, the Tennessee Constitution, is designed to be anti-majoritarian. It's supposed to protect the little guy against abuses by the government. And unfortunately, not everybody plays by the rules as they should.
Okay, so in this case,
Yes, sir.
you're asking us to suppress the dog sniff. Is that what you're asking?
Yes, sir.
And the basis for that?
Is that the dog could not differentiate between legal marijuana and illegal prior to the sniff.
Okay, and the dog can't differentiate between heroin and marijuana either, correct?
It can differentiate between that, but the problem was,
I thought you said that there were 4 substances that they would signal positive on.
but the training signals the same way for everything. And that's where the problem comes, so that if you take marijuana out and it signals it's with one of the 3 illegal substances, or the dogs could learn how to do a different signal for a different substance. But in this scenario, marijuana was the only thing here. And
Well, okay, back to Justice Tarwater's original question. Are you asking us to invalidate the dog sniff? You said no. What I'm now hearing is yes.
the dog sniff as it relates to marijuana, yes. The dog sniff in and of itself for other substances, if that's not included, no.
But you're requiring certainty. I mean, to totally just take out of the picture the alert as a factor that goes to the totality of the circumstances is really flipping the probable cause standard. You're saying that, well, if the alert does not establish with absolute certainty that what is in the car is illegal marijuana, then an officer just can't consider it.
No, ma'am. What I'm saying is if it can alert to something legal, that it needs to remove that basis.
How is that different from what I just said?
Because you're saying across the board, I'm saying if there is a legal substance that that dog can alert on.
What can we,
Go ahead, now go.
what can we actually consider here in our totality of the circumstances with respect to probable cause? We can consider the pine tree fragrances that were so strong, right?
Yes.
And we can consider the dog alert, right? And we can consider the fact that upon the questioning of the officers, the driver turned to the passenger and said, "You better start talking." And the passenger said, "Oh, that backpack between my feet belongs to my brother. I don't know what's in it." Can we consider that factor too?
I don't think so, because they've already been put in custody at that point. They've already been pulled out of the car. I think it would stop at that point. But the fragrances, just simply a strong smell in and of itself doesn't mean it's an illegal smell.
Well, how far back do we go here? We're talking about human officers, not dogs. If they make a stop for some reason, speeding, whatever, and walk up and the window rolls down and marijuana smoke just billows out of the car, is that probable cause now?
Yes, sir.
Okay.
Because
But
if the officer can testify that I know the smell of marijuana and that was it, and there's smoke.
But not hemp?
Yeah, what if they were vaping hemp?
Let me finish.
I'm sorry.
We know that they can smell the billowing marijuana. We also know that raw marijuana has a distinct smell, and officers can smell that. But I suppose raw hemp has the same smell. Is that right?
My understanding is to dogs it does. As to the vaping question, it'd be pretty easy to show, here's my vape pen. So, yes, there are
But
ways
are you arguing that an officer who walks up and smells raw marijuana no longer has probable cause because it could be hemp?
No, sir. What I'm saying is that a dog that can't testify,
I'm talking about humans now.
the humans, if the totality of the circumstances, the officer can show, I know marijuana smell, I saw them doing a joint, or they were billowing smoke as they came out, and the way they reacted, yes, that I think you can put together. Because the officer can be cross-examined. I can ask the officer, well, why did you think that?
What about just, there's no joint, there's no smoking in the car, there's just the raw smell of what officer can testify as cannabis? Where are we with that?
I think you're back to the totality of the circumstances of being able to explain what else did I have.
Okay, so if we're there with the human, why aren't we there with the dog?
Because I can't cross-examine the dog. And as long as the dog is beyond cross-examination.
So you've never cross-examined a dog?
No, sir. I've had a couple of dog cases before, but I've not cross-examined a dog.
Okay, I want to go back. You continue to say that the answer here is to basically retrain the dogs not to sniff for marijuana, but to sniff for the other things. And that they can possibly alert differently to different drugs.
Yes, sir.
again, I will ask you, is any of that evidence in this record in this case?
No, sir, it was done by stipulation.
Pardon me?
No, sir, it was done by stipulation.
Well, if there was a stipulation, is the stipulation in the record?
Yes, sir.
But what does the stipulation say about that?
The stipulation says that the dog alerted, only marijuana found, and that the officer smelled a strong smell, did not say what the smell was, and that the people in the car said it was pine aerosol fresheners.
But how is that addressing the issue of that you could retrain the dog and to either, number one, just eliminate the dog's ability to alert to marijuana, or to retrain the dog to have different alerts? You keep talking about that's an option here, but if there's nothing in this record, I just asked you what the stipulation said, so apparently the stipulation doesn't address that anyway, how can we even consider that?
Your Honor, I think this is a policy-setting court. The court can give guidelines as to how to address the issues. That was talked about in State versus West, I believe 1994. I'll be happy to address any further questions the court may have.
Thank you, counsel.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. Ben Ball on behalf of the state. Here, the Court of Criminal Appeals properly concluded that a dog sniff here was reliable, and the totality of the circumstances here yielded probable cause, regardless to the changes in the law regarding the legal status of hemp products. The defendant contends, as I understand it, that a dog trained to smell drugs, and if those drugs include marijuana, that dog is somehow per se no longer reliable. And that was the question presented to the trial court here. As my friend on the other side noted, all the facts here were stipulated. And what was also stipulated to was that the dog was otherwise properly trained. The only question about the dog's training and its reliability.
When you say otherwise properly trained, what do you mean by that? Trained to detect all 4 drugs?
It was otherwise properly trained as far as this record goes, unfortunately. I would love to sit here and tell you that there are 3 other substances for certain that sort of increase this calculus of probable cause. And it's my understanding that's typically how the dogs are trained. Those facts are not in this record. It's simply this otherwise properly trained.
Well, Mr. Ball, let's just go straight to the chase here a little bit then. I mean, the foundational principle that from the U.S. Supreme Court, even from the U.S. Supreme Court and now on down, for purposes of allowing dog sniffs and taking the position that they don't constitute a search, has been the binary search doctrine, right?
Yes, Your Honor.
Now, is that binary search doctrine turned on its head in this situation now, because you cannot tell the difference between hemp and the smell of hemp and marijuana?
Your Honor, I would say this is not. And as far as the question of whether this is a dog sniff is somehow become a search, I would suggest it's not before this court. The question simply put to the trial court was the dog reliable? And the question of reliability, as the court noted in England and as our United States Supreme Court explained in Harris, is based on this training. Does the dog do what it's trained to do?
But my question is specifically, based on the binary search doctrine, the reason, the theory behind allowing the dog sniff, and in doing so, holding that it's not a search, is because the dog will only alert to illegal products, correct?
Correct.
That is not the case anymore, correct? That because if the dog, and it's certainly not the dog's fault, can't tell the difference between marijuana and hemp, then that background, that foundational principle is turned up on its head, is it not?
Well, what the dog alerts to is the cannabis plant, and the cannabis plant now covers both what we would now call marijuana and what we categorize as hemp. And the reliability of the dog is based on its ability to do as trained.
But you're not addressing my question. My question is, the foundational theory is that they can do this because they can differentiate between an illegal substance and a legal substance. If that's no longer available to them, what is the foundational principle upon which we should say that a dog we can have a dog sniff and it does not constitute a search?
Look, there's a sort of one-to-one lineup here with what the dog can smell. I mean, if it is trained to smell the substance, it detects the odor of that substance, and that is what it's indicating. It's not indicating whether that substance is legal or illegal. It is indicating that there is cannabis sativa plant, or at least the odor of that plant, present. And that is fundamentally what we look at when we look at the reliability of the dog.
Mr. Ball, I mean, I understand that well, let me just clarify so the search issue has not been raised. Is that correct?
That is correct.
So the defendant in this case has not argued that the dog sniff, because of these changes, is now a search.
That is correct. He has not argued that. He has not challenged the stop. There are a number of issues sort of floating around the perimeter of this case that aren't really before this court.
So that may be a question that we need to address another day, and I think that is a much more difficult question.
Yes, Your Honor.
But the question before this court in this case is specifically whether and to what extent the positive alert from a drug dog can establish probable cause.
That is correct, Your Honor. To the extent that it affects its reliability and then to the total probable cause scenario. As I understand it, the defendant is asking this court to overturn England. As this court noted, England did not adopt a per se rule about a dog alert. England includes the totality of circumstances, and 13 years later in Florida v. Harris, the United States Supreme Court essentially said the same thing.
Mr. Ball, what is in this record, or this stipulation, I guess, other than the dog sniff to support probable cause here?
So what we have here is very similar to what we have in the state of England. And I could argue that we have a little more. In the state of England, we just had the alert and suspicious behavior. Here we have suspicious behavior on behalf of the occupants of this vehicle in that they deny knowing the source of a backpack that is between the defendant's feet. On top of that, we have these 3 pine tree air fresheners that are emitting sort of a strong odor. I think a reasonable inference from that is that it's trying to mask, the possibility is trying to mask another odor. And then we have the comment made by the car's driver after the dog has walked around the vehicle that he needs to explain, he needs to talk to the officer, and he provides some sort of explanation. Now this is backpack he recalls it belongs to his brother. Your Honor, I would suggest this court that is significantly more than we had in England, and that the Court of Criminal Appeals got this right in concluding not only that the dog was reliable, but that the dog alert, when added to the rest of the circumstances here.
Can we say the dog's reliable because it could be alerting on hemp, which is a legal substance?
I think we can still say the dog is reliable because when you look, when Florida v. Harris talks about a dog's reliability, it says what we're talking about is the dog's training in a controlled environment, and if that dog is consistently identifying the smell of a substance that they know to be there. And then it says, now we can also look at other things that sort of go into the totality of the circumstances for probable cause. Did the trainer do something to make the dog alert? Were there circumstances surrounding this that might cause a dog to false alert? And I think that's particularly valuable in the context of legalized hemp. Because the scenario that sort of is worrisome is that my friend on the other side talked about. An officer who sets up shop at the hemp store and then just runs the dog around every car in the parking lot after the customer comes out. That would factor into the totality of the circumstances. And I think that's a very different scenario than what we have here.
Are you arguing, though, that, so I guess there are a couple of different ways to approach this. We could say, absent circumstances that suggest that the individual is possessing lawful hemp, rather than unlawful marijuana, a positive alert from a drug dog is sort of enough on its own or in combination with some other, minor circumstances to establish probable cause. A different approach would be to say that, you have to have the positive alert plus some circumstances affirmatively suggesting that what the defendant is possessing is unlawful. I'm not sure my question is completely making sense, but do we have to? Does it have to be positive alert plus something showing illegality, or is the sort of the drug, is the positive alert, and then nothing else suggesting, like no circumstance showing that you're parked outside of a hemp store, for example, or that you're pulling over a car that is, labeled with the name of a hemp retailer. Is this making sense? I'm sorry if it's not, but it is totality of the circumstances. But I guess we could give some guidance about what circumstances are sufficient.
I don't know that we need sort of what sort of probable cause plus test. I think totality of circumstances already encompasses all of this. I do think when you look at some of the CCA case, the Court of Criminal Appeals case law, talking about England, that sometimes it's a little scant, that it does almost give the impression that it's a per se rule, which it's not. I think guidance can be given there, but I think the current probable cause standards as it exists encompasses this. Because we're talking about common sense probabilities. We're not talking about absolute confirmation. This is a standard that's,
Well,
No, go ahead.
so it sounds like you just kind of hit upon where I was going to go next, and that is, I hear Mr. Smith saying totality of circumstances. I hear you saying totality of circumstances. I understand Tactile in its amicus brief argues for totality of circumstances. So really the problem has come in what you just talked about, and that's the loose language in some CCA opinions that would seem to indicate that it's per se probable cause when the dog alerts, and that's what we really need to clean up here. Is that a fair statement?
I think that's a fair statement, and I don't know that there, I can identify any Court of Criminal Appeals cases where they outright say it's a per se rule, and a lot of times they're just sort of breezing through this part of the analysis. I do think that some people may have gotten that impression.
Well, to be fair to the CCA, sometimes it's just clear that you have probable cause. It's no need to discuss it that much.
That's exactly right, Your Honor. In a lot of cases, it's one of many issues, and it's a pretty simple, straightforward analysis. But there is no per se rule from England, and this court doesn't need to overturn England to make that clear.
Mr. Ball, you suggested, I believe in one of your responses to an earlier question, that it might be relevant that there is no. So if someone had hemp in the car, for example, lawful hemp, you might expect that upon being pulled over, they would say, oh, by the way, I have this, I've been vaping, this is lawful, like offer up front an explanation as to why there might be the smell of cannabis in the car. But this kind of goes to my earlier question. I'm going to see if this makes more sense, and I apologize if it doesn't. But is the absence of that sort of innocent explanation in combination with a positive alert from a drug dog enough under a totality of the circumstances test?
If there's anything that together with the dog's alert satisfies the totality, I don't think it has to be that there's no requirement for an officer in the situation to sort of look for an equally innocent explanation.
Is it significant that, this regulatory scheme for hemp is pretty complex? So, it's not a kind of a binary, either it's hemp that's under, 0.03%, or it's illegal marijuana. There could be sort of another category of, well, maybe it falls into that under 0.03% category, but it's not packaged properly, or it doesn't satisfy, a host of other regulatory requirements about how this stuff has to be, stored and transported. Should that factor into our analysis?
I think it should factor into this analysis that the smell of the cannabis plant, even in circumstances where it may be hemp, can still be indicative of either criminal behavior or evidence of a crime. For example, it would still be illegal to consume a large amount of a hemp product that has THC Delta 9 or Delta 8 for that instance, and then drive while under that intoxication. So I don't know that there has to be, there doesn't necessarily have to be evidence of that this was not an industrial hemp product that is,
Okay, in talking about the totality of the circumstances in this particular case, the defendant's answers about the backpack, squirrely answers about the backpack, and the strong car deodorizer type scent. Mr. Smith makes the point that, I'm not sure I completely understand it, but makes the point that it happens after the vehicle is stopped, so it doesn't count. So would you address that? I'm sure I'm mischaracterizing the argument, but it's partly because I didn't quite follow it.
So to be clear, the stop that started all this was not challenged below. So I think from that standpoint, we begin with the situation. This was a legal stop. The question posed to the trial court, and this was as close to a sort of almost a certified question that a trial court could get, because all the facts here were stipulated to, and the question was, is the dog now unreliable because of the change in the law? The stop wasn't challenged, and I don't think that really factors into this.
Mr. Ball, I have a different slant on a question that I'd like for you to respond to. Let's assume, for the sake of argument, that good Tennesseans grow a lot of hemp, and that the state supports Tennessee farmers in growing hemp, that hemp has a wide industrial use, also has a recreational use. Now, shouldn't those good Tennesseans have a reasonable expectation of privacy that they would not be subject to a search when a dog signals the presence of a legal substance?
Your Honor, I would suggest to this court that it has always been the case that the circumstances that lead to probable cause may end up recovering nothing. And I really think this is analogous to the situation you had in Florida v. Harris, where we're talking about the lingering odor of a drug. It's possible that a drug dog can be right and still not uncover evidence of a crime or contraband. Probable cause is about probabilities. It's a common sense standard. It's not it's not one of mathematical certainty. So if your honors have no further questions, I would simply urge this court to affirm the judgment of the Court of Criminal Appeals here. Thank you, your honors.
Thank you, counsel. Mr. Smith?
Your Honor, I believe my time is up.
Oh, yeah, that's right.
Answer
All right. Appreciate it. No questions?
Yes, 5 minutes.
okay, all
I
right.
asked for 5 minutes, but it went through the 30, so I'll do whatever the court.
We'll give you a couple.
Justice Page, you would ask about the stipulations. If you look at page 17 and 18 of the technical record, that under the factual history is the stipulation. And then if you look at page 23, that is the the state acknowledging that the facts are correct as stated. I'll be happy to address any questions the court may have.
Thank you.
Thank you, Honor.
Appreciate your arguments, counsel. The case will be submitted. Our docket today is complete.
All rise.
Don't forget to like, subscribe, and hit that notification bell to stay in the loop with all things justice. Thanks for tuning in to Black Justice Media. Remember, your voice matters in this fight for justice. Catch you next time, Church.